Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Mark Erickson. Mark Erickson is a family law attorney whose firm is located in Campbell, California. He graduated with a JD or law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. After working for another attorney, mostly in the areas of civil and business litigation from 1979 through 1984, he founded his law firm in 1985. He became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. Mark plays amateur ice hockey in his other life, and he has 2 adult sons, and one of his sons is following in Mark's footsteps as a lawyer. Congratulations.
Thank you.
Mark, thanks for joining me today. It's a pleasure having you as a guest.
Thank you.
So today, Mark and I are going to be talking about the basics of issues related to the family residence for a divorce in California. And this is a complex area of law for which you should consult your own attorney. So this is just the beginning, we hope, of a conversation that you'll be continuing to have with your own attorney. We also want you to remember that divorce laws vary among the states. So for example, in California, we have community property, and we have our own peculiar form of community property. Community property, for example, in Texas is different from community property in California, I understand. And we're not going to have time to cover everything. We're just going to hit some highlights. So you've all been put on notice, but on the other hand, this never stopped me from tackling difficult subjects before and trying to get some information out to get people thinking about important things. All right, Mark. It seems like handling a family residence should be pretty straightforward. Just sell the house, split the proceeds. More to it than that?
You'd think it would be easy, wouldn't you? And I think a lot of times both spouses going through a divorce think it would be easy if it could just go the way they want it to go. But it's the family residence very often is the biggest, most important asset built up during a marriage. And certainly it's an asset a lot of people have when they go through a divorce. And there are a lot of different types of disputes people can have over a family residence. Just outline a couple of them. Who's going to keep the residence, or is it going to be sold? Is it community property or separate property, or perhaps some of each? Are there other owners other than the husband and wife that have an interest in the property?
See a lot of that these days, don't you?
Yes.
Mom and dad helping out.
Who's responsible for the debt? If the house is underwater, meaning it's worth less than the mortgage or mortgages, how do we deal with that? In the short term, after separation, who gets temporary use, possession, and control? What if both people want to stay in the house? What if one's out? Who's going to pay the mortgage, taxes, insurance, and upkeep? So there are a lot of issues that can come up both immediately on separation as well as the final decisions about ownership, sale, or buyout of the residence.
So as the old saying goes, the devil's in the details, huh? Okay, well, let's get into some of this stuff. Is the residence just divided 50-50?
Not necessarily. If the residence is entirely community property, it's going to be divided 50-50. California is a community property state, and so it could be as simple as the house is community property, the debt is community debt, and so if one spouse is going to keep it, the spouse who retains the house would owe the other one half of the net equity, although that's negotiable on how you get to that number, or you'd sell it and divide the net proceeds equally, assuming everything else is being divided equally in the dissolution. That's the easy part, but there often can be separate property claims reimbursement claims. One of the most common claims we see is reimbursement claims related to down payments on the family residence from separate property sources. This may have been the initial residence the parties bought, or one of them may have owned a residence before marriage that they sold, used the money from that sale to buy the current house, or they may have had a succession of houses where they bought multiple homes during the marriage, and there's an issue about whether one or sometimes both spouses can trace back the down payment, principal pay down on mortgages, or improvements to a separate property source. That can get very complicated, especially after a long marriage where you have lots of refinances and lots of improvements going into a home.
Now, this claim that we're talking about, that gets paid first before you split the rest?
Yes, Family Code Section 2640, I'll call it a priority claim, certainly not against mortgages or other liens, but from the equity in the residence, it's paid off the top. So just hypothetically, say there was $100,000 in equity in a residence at the time of divorce, and one spouse can establish that they contributed $20,000 of their separate property toward the down payment years earlier. They would get the $20,000 off the top. The remaining $80,000 would go $40,000 to each spouse as an equal division of community property. Now, this law only applies to contributions made on or after January 1, 1984. And so we're still seeing claims that could precede January 1, 1984, where we have a different body of law that's still in effect today for those transactions.
Okay. So do the spouses always agree on these contributions of separate property, or are these things they argue about?
They commonly dispute these claims. So when one spouse makes the claim, the other one usually says, prove it, show me, and demonstrate that you can show that you made the down payment or improvements with what was actually your separate property. And sometimes that's complicated because a source of separate property may be coming through an account that's been commingled that requires some preliminary tracing of other assets to determine the character of those assets to see if there was separate property available to make the down payment. A very common dispute comes up where money comes from family members. So you see certainly a lot of young couples that get married, one set of parents, so say husband's parents, gives the parties $100,000 for down payment money to buy a residence. The divorce comes up many years later, and the husband says, that was a gift to me, so it was my separate property, I get the $100,000 reimbursement. And the wife says, no, that was a gift to the two of us. We each have a $50,000 reimbursement. Or the parents come along and say, no, it was a loan, you owe me $100,000 back.
Oh boy, now we got a three-way conflict.
That's right. Or both sides' parents have put money in, maybe with or without written agreements that may not be clear.
Oh boy, how fun. See, now, I did it the right way. I got married when I was 19, neither one of us had anything. It's all community property. Well, sort of, until a few years ago my in-laws passed away, so now my wife has actually quite a bit of separate property. But up to that point, things were pretty easy. Now our lives become more complicated. All right, well, are there issues related to refinancing the house?
Well, one of the concerns people should be aware of, and they aren't in this era of multiple refinances, is when you first buy your home, that original mortgage, we call it a purchase money mortgage, is exempt from a deficiency judgment, meaning the lender can only go after the security if they try and foreclose on the mortgage or deed of trust, in California anyway. And so they can't get a deficiency if the home ends up being worth less than the mortgage. Once you refinance, you lose that anti-deficiency protection, and you have the risk of owing more than your home is worth. And this can come up in negotiations and disputes currently. we never used to see this, particularly in California. The last few years is the first time I've ever seen any true depreciation in value of residences. There may have been, after the 1989 earthquake, things cooled down for about 5 or 6 years, but they were relatively flat. But in recent years, what I've seen is most young couples that come in for a divorce are upside down, meaning they owe more on their house than it's worth, and they may have refinanced, and so they, or maybe they haven't, and they either have a risk or no risk of a deficiency. And this can be a consideration when we're trying to determine, what do we do with the house? Do you try and go through a short sale? Does one spouse keep it? And this is where there's a big area of dispute right now. If one spouse retains the house, do they take it at a negative value, meaning they get credit for essentially that debt in excess of the value of the home to offset against other assets or debts the other spouse may take? Or do we give it to them at a zero value? And the law isn't really clear at this point on exactly how we do it. So there's a lot of serious negotiations going on these days that will probably continue until we see some more upside in home values.
And you mentioned that we had some different laws about some of the stuff before 1984.
Yes, before 1984, the difference was the issue of reimbursement for separate property contributions to a community property residence. Before 1984 legislation, the law was that if a spouse could prove an agreement or understanding with their spouse concerning a separate property contribution, that agreement would be enforceable. Now the reality is, and I tried a few cases before 1984, or at least under that law after 1984 for older transactions, and very difficult to prove. Because the fact of the matter is, very few spouses really think about and talk about these things. They're excited to buy a house, they get the money however they can get it, they title it however it makes sense at the time, and they don't really think about the consequence until there's a divorce years later, and then they realize some of these things were important.
Yeah, okay. Wow, sorting out these details seems like a difficult project. Is help available?
Well, the help that we get is not a lot in these areas. Usually you don't need an accountant unless you have a real tracing issue. So sometimes we will hire a certified public accountant or forensic accountant to assist in determining the source of down payment or improvement money put into a residence to try and establish a separate property claim. Of course, often we use appraisers. If one or both spouses want the house, each side will either get an appraiser, or the court might appoint a neutral appraiser to determine the fair market value of the property.
Okay. Now, again, we've been talking about these separate property reimbursement claims and so forth. Are there any cost of living adjustments? So, for example, if I contributed $10,000 for buying my house 30 years ago, I mean, that would be like contributing $100,000 probably this year. Is there any consideration for that, or even an interest, adjustment or anything like that?
You would think that in fairness there would be, but the statute says no. So if you show, say, 1988, you put $100,000 down on a home and say today it's worth $3 million, you get your $100,000 back, and that's it. No adjustment for inflation, and you don't get any portion of the increase in value. That all attributes to the community. So the increase in value would be split 50-50 between the spouses. This, again, we're assuming that this home is titled as community property.
Well, in most cases, actually, most homes are community as joint tenancy, but I understand that means the same thing as community property for a divorce.
Correct. Yeah, joint tenancy property is treated as community property in a divorce, but it's not uncommon for a home to be titled in one spouse's name as opposed to both, and that's another area that's ripe for dispute. And we see a lot of that for various reasons. And sometimes it's just I'll say, complete trickery on this part of one spouse trying to take advantage of the other and having the home in their own name, even though it truly was community property. Sometimes people are forced into it because one spouse may have very poor credit, and so they'll buy the house and take the loan in one spouse's name because they get a better interest rate on their mortgage, or maybe qualify for a mortgage that they weren't otherwise able to qualify to buy the home. There's been a lot of litigation and case law in recent years addressing this issue of changes in title to the family residence during the marriage. I don't know if you want to go into that.
Mm-hmm. Well, we'll get into some things probably related to it a little bit later, although we'll see how the time goes. But I think the next subject that I wanted to get into, and sort of in the sequence that we talked about, is if one or both of the spouses want to keep the home. And I think the most common situation that I can think of where they would want to, other than that they just have maybe a sentimental value, maybe we're talking about that they bought mom and dad's home that they're living in now, can be a reason. But I think the main one is that people want to stay in a home until their children are grown, or one of them. So what are some issues related to that?
Yeah, and that is a common concern, particularly if one parent has primary custody of children or sole physical custody of children, which is less and less common as time goes on. But even if they have joint custody, a parent may feel that the children have an emotional attachment to a house, particularly children by the time they're in junior high or high school often have a very difficult time moving away and trying to form new friendships in their high school years. So one parent often will want to keep the home for that reason. We call it a family home award. There is a body of law that addresses that issue, but in the reality is, as applied in the courtroom and in negotiations, you do not see many family home awards, and the ones I've been involved in, it's almost always by agreement. Years ago, I had a couple of trials concerning family home awards. I thought they were pretty strong cases, and the judges denied them. I just don't see people seeking them other than trying to persuade their spouse to delay the sale of a home. So by agreement, yes, people will negotiate an agreement where for at least some period of time, maybe till the youngest child graduates from high school, they won't sell the home. Then they'll sell it and divide it either equally, as they may have had they divided it presently at the time of dissolution of marriage, or conceivably they could do it unequally. These orders can be somewhat complicated because you have to take care of concerns such as who's going to pay for the maintenance, what about responsibility for the mortgage, what about tax deductions on the mortgage, and the outspouse has to be concerned about tax law and their future potential liability for capital gains tax liability, and the fact that they may lose their at least under current law, they have a $250,000 exclusion from capital gains treatment on sale of the residence, and losing that exclusion could cost them a lot in state and federal income taxes, and I think that dissuades a lot of people from agreeing to family home awards when they think about the tax implications and the penalties that might be involved.
So you brought up that issue, the tax issue. Maybe we should just talk about it for just a moment. So my understanding is that that if you have a court order type of a situation, that you can continue to treat the use of your former spouse as your own use. Maybe you can make some comments related to that.
Yes, absolutely, and in the short term, we're very concerned about that. So very often, if one spouse is in the house and the other one is out, we will, in an initial court order, agree that the in-spouse has exclusive temporary use, possession, and control of the family residence. This actually protects the out-spouse and treats them for tax purposes, for purposes of this capital gain exclusion, as if it's still their residence. But when we're thinking of a family home award that might last many years, we can't look into the future and know what the tax law, right? I guess sitting here today in 2012, we don't know what the tax law is going to be in January 2013 right now, let alone what the tax law might be when somebody's children turn 18 10 or 15 years from now. But yes, that is a concern, and absolutely, if you did write an order for a long-term family home award, giving one spouse use of the home before they buy out the other spouse or sell it, you'd want to have that in there to try and protect the out spouse and at least give them the potential of deferring some capital gains or avoiding some capital gains taxes.
Right. And you mentioned to me that I guess sometimes attorneys forget to get the court order, and so then that other spouse isn't protected.
That's right. Yeah, I guess that's a consequence of people being not either uninformed by choice, not getting legal advice, perhaps doing these things on their own, or using an unqualified neutral or mediator that doesn't address these issues, or not talking to their certified public accountant to be aware of these sorts of traps they could walk into.
Well, and this isn't the sort of thing that CPAs just know off the cuff in most cases. I mean,
I find that's true. And there's some very good CPAs that are excellent within their field, whether it's tax preparation, audits, or whatever it is they do. But what I find is a lot of the CPAs that prepare tax returns are a little bit baffled on how to prepare those returns and what sort of advice to give to people immediately following separation, and how to prepare those first returns at or about the time of divorce.
Yeah. Okay, well, we talked a little bit about the issue of changes of title for property related to refinancing and so forth. So why don't we get into that a little bit? So what sort of issues do you see related to that?
To titling?
Yeah, so I think what we're talking about is quite often it seems like the company that's making the loan has requirements that you need to meet in order to get the loan, and so they ask for changes in title.
That happens.
Okay, so maybe you can talk a little bit about the situation.
Yeah, so the law tells us that there is a presumption of undue influence where one spouse gains an advantage in an interspousal transaction. What does that mean? Well, when practically applied, this frequently comes up in the area of the family residence. So let's just say the house is titled as one spouse's separate property because they owned it during the marriage, or maybe they inherited it on death of a grandparent. And now they want to refinance to put on an addition or pay some debt or get a lower interest rate. And the spouse who owned it as separate property, maybe they have bad credit, or for whatever reason, the other spouse convinces them to put title in both names, or maybe exclusively in the other spouse's name. The law says there's a presumption of undue influence, and we see a lot of these cases. I'm surprised at how many times we see title changes during the marriage. And the spouse who is advantaged by the transaction is subject to the court, having the court set it aside and restore the deed title to what it was prior to the transaction, unless they can show the other spouse really knew what they were doing. Were they fully informed? Did they understand it? Did they have a lawyer? Was it explained to them? Was it a fair transaction? And some of these transactions may be entirely fair. Was there consideration paid? So the spouse that was advantaged, maybe they gave something in return for it. But if they can't establish what they need to show to overcome the presumption of undue influence, the court should set those transactions aside. And I'd say it's a very common part of family law litigation these days.
Yeah. So related to this, one, it's very common to see things happen related to these refinancing where they change title. I mean, a very common one, for example, is to take a property out of the title of a family trust, put it in the individual names, and the title, the loan company has no interest in getting that restored. It's really up to the owners to do that. And the problem is people don't pay attention to these details, life goes on, whatever, And so that means that it's leaving messes to be cleaned up at a later time, and probably it's going to cost some money in order to do it.
Or maybe too late. I can't tell you how many times I've heard the story from a wife telling me years before her husband promised he was going to put her right back on title after they put on the addition or got the new loan or he got his inheritance or whatever it was, but it never happened. And now years later, the other spouse is denying they ever made such a commitment and gives some rationale for why the title was changed other than what the person who went off title is saying occurred. So it's something when people enter into any major transaction during a marriage, they should think about it. Think about the implications, not only on the possibility of dissolution, but every marriage is going to end by either death or dissolution. And people often go into important transactions and give little or no thought to the effect of those transactions.
So it may be that even when you're doing a refinancing or whatever, let's just say any major transaction, I mean, well, people are reticent to get legal advice, but maybe they should be, and maybe they should actually have some little written agreements about what their intentions are.
Absolutely. Unfortunately, when it comes to title changes on the residence, the story I hear frequently is the spouse who signed off on the deed transferring title to their spouse didn't know about it until they showed up at the title company and were handed a stack of documents to sign. And even then, there are a lot of people, surprisingly, that'll claim, yeah, that's my signature on the deed, but I didn't know I did it and I have no recollection that I did it. Yes, I remember signing a bunch of papers, but I had no idea I was conveying my interest in our home solely to my spouse, or my separate property half to my spouse.
Oh my gosh. Mark, we're all out of time. So thank you again for joining me as my guest today.
Thank you.
Folks, I think we've given you some important information to think about. This stuff is a lot more involved than a lot of people think. So anyway, do get good legal counsel when we're talking about a divorce, and particularly related to your residence. We'll see you next time on Financial Insider Weekly.